Hi, this is Brad Hennings with CCK Law, and we're here today to talk a little bit about the concept of new and relevant evidence. So, one of the three appeal options under the Appeals Modernization Act, or AMA, is a supplemental claim. Common examples include service connection denials, increased rating claims, TDIU requests or claims, and effective date disputes when arguing that a new theory or evidence supports entitlement. So for service connection denials, a lot of times you have newly obtained medical nexus opinion evidence. For increased rating claims, you have new test results or treatment records showing worsening. For TDIU claims, you can have vocational expert reports showing functional limitations. And so that's some examples of the kinds of evidence that are involved. So a supplemental claim is useful in cases where a veteran feels that VA would make a new decision if they had additional information or evidence. But by law, a supplemental claim must contain new and relevant evidence. Not only is that language very specific and important, but it's also a change from the old standard, which applied to appeals before 2019, which was new and material evidence. And we've seen many veterans getting confused by these differing standards, which is completely understandable. So what does new and relevant mean? And how is it different than new and material? So the new and relevant evidence standard applies to supplemental claims under the Appeals Modernization Act, or AMA. The authority for this is 38 CFR, section 3.2501. New and material evidence was applied and is applied to legacy reopenings. So it was the system before the AMA, the legacy system, prior to 2019. That authority is under 38 CFR section 3.156 a. So the new and relevant evidence standard, the definition is that new means the evidence was not previously part of the record, and relevant means the evidence tends to prove or disprove a matter at issue in the claim. And this is under 38 CFR section 3.2501 a. This is a lower, more veteran-friendly standard than new and material. Evidence does not need to raise a reasonable possibility of substantiating the claim, and evidence does not need to be outcome-changing on its face. Again, it has to be new and relevant. The AMA intentionally relaxed the standard to make reopening easier. So here's an example. A veteran submits a new medical journal article linking burn pit exposure to their claimed illness. It is new because it wasn't in the claims file or VBMS. It is relevant because it relates to nexus or the connection between the disability and the veteran's service. So VA must re-adjudicate in that case. Now, the new and material evidence standard, which was in the legacy system, is as follows. The definition. New means the evidence was not previously part of the record, so that's pretty similar. But material means the evidence relates to an unestablished fact needed to substantiate the claim and raises a reasonable possibility of substantiating the claim. This standard is higher and more difficult to satisfy. So the evidence must be significant enough that it could reasonably change the outcome, and it must address a previously unproven element of service connection. In other words, nexus, in-service event, or current disability. So here's an example of the new and material evidence standard. A veteran previously was denied for a lack of a medical nexus, but they submit a new medical opinion. But the medical opinion is speculative. It may be new, but it is not material if it does not raise a reasonable possibility of substantiating the claim. VA may refuse to open in that case, even though technically they probably should. Again, it's a higher, more difficult to satisfy standard. So for more information about appeals and supplemental claims, check out the CCK Law website at cck-law.com. Take care.